Welcome back to the Weekly Friedman, your source for the most essential information in the default industry. Traditionally, there's been a widely held presumption that there was no right to a jury trial on foreclosure matters in Pennsylvania. A recent decision debunked that presumption. I'm Adam Friedman, managing partner at Friedman Vartolo, and joining me today is partner Catherine Aponte, and this is actually her third time, so she's a regular on the show. Catherine oversees our Pennsylvania foreclosure department and recently wrote an article on this topic that was published in ALFN's Angle magazine. Congrats on the publication. Thanks for joining me, Kat. How's it going?
Thank you. Good. How are you?
Doing pretty good. All right. So can you walk us through the rationale used to render this decision? Is something being overturned? Where did it come from?
Sure. So to keep it simple, basically the judge relied upon a lack of explicit language in the Pennsylvania rules excluding jury trials for foreclosures, and based upon that exclusion or lack of explicit language, he applied the Pennsylvania Supreme Court test to determine whether a jury trial right exists and found that one does exist.
So was this surprising? Did the bar anticipate a decision like this coming, or did it kind of come out of left field?
I don't think it was necessarily surprising because it's very clear that there was an explicit lack of language in the rules. However, I think that there was a wide presumption that foreclosures don't generally have a jury trial. So it was surprising in that sense that it was formally laid out in such a thorough analysis.
Okay. How important is this? Look, I imagine a defendant in a foreclosure trial would like to have a jury. They're in a sympathetic position. But does this dramatically change the outcome of a large percentage of foreclosure matters? How big of an impact does this have?
So the impact really depends upon how many of the borrower's attorneys and the legal services in certain counties like Philadelphia take advantage of this outcome and are applying properly for a jury trial at the outset. And if they do, it can be used pretty effectively considering the fact that juries or trials are common in Pennsylvania.
To summarize, Pennsylvania defendants in a foreclosure action have the right to a jury trial if they request them. Additionally, it's important to note that this change or clarification came from a judicial order and not legislative or executive action. Thanks for joining Catherine Aponte and I on the Weekly Friedman, your source for the most essential information in the default industry. Join the conversation. Leave a question, a comment, really anything. We'd love to hear from you. Look forward to seeing you next time, and thanks for tuning in.